Good evening. My name is John Milburn, and this is LAWS 11057 Introduction to Law. This is week 2 in term 3, 2018. We have a number of people online. Thank you all for joining us. We have a special guest, Amanda Jane George. Dr. George is joining us this evening as well. So thank you, AJ, for joining us. And for everyone, we really appreciate your attendance at the live session if you can. As a reminder, if you can't make the live session, please ensure that you study the weekly sessions as you proceed and ask questions. Now, I guess you're wondering how to go about the process of asking questions, obtaining some feedback in relation to the answers that you provide to the weekly problems. Time permitting, we'll cover all of that during the weekly sessions, the live sessions, but I do expect you to read in advance, read the material set for the week, and to answer the weekly problems. Don't please just answer your version of the weekly problem. I do encourage you to make comment on each other's work. Now, I know that we're all very good collaborators, so we'll be very sensitive about the way we do that, but we do need to have a collaborative spirit, and part of that is to exchange ideas. So if you are able to provide some assistance, guidance in a gentle way, please do so. AJ, how are you doing?
I was going to say something there also, and that is not a wasted exercise, any stretch of the imagination, because developing that critical skill that comes along with going through what everyone else has said before you, and then making comment on that in a constructive way, it helps your analytical skills. But also when they hit subjects like me, like contract, they're going to have to do things like that as an actual assessable item anyway. So it's good for them to get into the habit of, you know, engaging in constructive critique and debate now.
Absolutely. So thank you, AJ. So what we're looking to do is have you think and act like a lawyer. I know that many of you won't be practicing as lawyers, and some of you are undertaking this unit without undertaking a full law degree. You're just coming in to do Introduction to Law. I totally get that. Just as on that point, for the first assessment piece for your professional portfolio, if you're not intending to engage in a legal career, then simply tailor your portfolio to suit your needs. The idea is that this is something that you will be able to use for yourself. So don't make things up thinking that's what I want to see. To be honest, in relation to the first assessment for the portfolio, I'm much more interested that you can submit your work on time, submit your work in a professional manner, have some understanding of the technology, use the technology well, link to appropriate artifacts, and that's the sort of assessment that I'm after. Now, if as part of your artifact you say, well, I have 3 doctorates in different areas, that's very impressive, but you won't receive any greater mark from me in terms of your portfolio than a person who says, look, I'm 15 years old and I really haven't done that much externally to school. So what I'm really getting at is this. It's not necessarily what you've done in the past, but how you present your portfolio at this stage as a genuine reflection of yourself that will provide me with the opportunity to grade you. And don't be too concerned about the grades for this first assessment. It's a pretty easy task and it's pretty easy to pass. Don't spend a whole lot of time on it because we've got a lot more that we need to do. And I really want you to get the platform ready and submit a good platform, and you can build on that week by week and year by year through your studies and even through your career. As I mentioned last week, you have the opportunity to keep the portfolio. Now, what you need to do is be aware that by way of background work, Associate Professor Scott Beattie and I are setting up the CQU net accounts, and once they're released, I will let you know. So don't attempt to submit your work now. You need that CQU net account. Now, there's a question about the weekly problems. So you know where the weekly problems are in the Moodle section. If you don't, please go exploring and find them. The question is, do we post our general 20-minute answers on the discussion forum each week? And the answer is absolutely yes, please. And I will be looking for that. And even though there is no direct mark for participation, I can assure you that the work that you do in the weekly problems will assist you when it comes to the end of term, and it's designed to assist you understand better the way in which this unit is to be conducted. So if you have any questions, please feel free tonight to use the chat facility or unmute the microphone, and we'll conduct a couple of quick polls. I probably won't use the poll device, but I'll just ask for you to provide some feedback as we go. Now, I have indicated the importance of looking ahead. So at this stage, you should certainly be looking at the week 2, 3, and even 4 material, and you should be glancing at the rest of the unit so that you've got an idea of what we're trying to achieve, and you can work back from that. Communication is an important part of the unit that we cover. Now, in the first 2 chapters of your text, you have a lot of valuable information in relation to law as a profession, the realities of legal practice, and the attributes that you need to be a successful lawyer. So read those carefully, but also read them critically. By that I mean, take time to reflect. And you have the luxury in these first few weeks of being able to reflect on things a bit and ask yourself some questions about where you fit in to the unit and how you will practice, how you will undertake the studies that we need you to consider. If you do decide to go on and use your law degree in terms of employment, then have a look at the work sectors and ask some questions about what might suit you if you choose to go into a legal career as such. I think I mentioned last week the Priestley 11. Did I mention Priestley 11? You'll hear this from time to time. So when we talk about the Priestley 11, there are a series of units or courses, if you like, which create the core courses, and they're referred to on page 26 of your text: administrative law, civil procedure, company law, etc. AJ has a particular interest in number 5, contract law. So these are the key areas of practice that you must concentrate on and undertake as part of your overall degree. And then there are, of course, some electives to go beyond that. In terms of making the most of your legal education, feel free to go beyond the textbook, go beyond the studies and the discussions that we have during this unit, and think about, if you have time, think about attending court. They're generally almost always open to the public. It will give you a great feel for the practice, and many practitioners were very happy to have a chat to you. Some might even say, while you're here, let me take you in, introduce you to the magistrate or a judge. You know, you may have that opportunity. Also, think about attending your community legal centres. If you're in Rockhampton, Wayne Jones and Farmer have been promoting the community centre in Rocky. There are community centres elsewhere. I co-established many years ago one in Harvey Bay, Maryborough district. So community legal centres, another great place to go, and there's a lot of good resources available to you. You might be able to volunteer, or you may be able to sit in with practitioners as they provide advice. That is, of course, if the clients are willing to allow you to do that. And mock trials. So quite often you'll see an opportunity to compete in a mock trial. If you have that opportunity, even if you're as a witness or as a jury member, a mock jury member, please keep that in mind. Whatever you do, okay, so we've got, Rachel says attending court sounds interesting. Ben went last week, had a chance to chat with a judge. Benjamin, do you want to tell us about that? You don't have to mention names, but was that a worthwhile experience?
Not too sure that's working properly.
We can hear you.
Oh, okay. Yeah, it was really, really good. It was a little bit embarrassing. I was the last one in the courtroom, and I was approached and asked if I had any matters before the judge. Mentioned I was a law student. Asked what I was interested in. Asked my background. Asked how many children I had. How much time I had to read. and then basically talked about when he was hiring solicitors, and said that anyone that was a mature age student and had a background in another industry, he always gave a go, which was very encouraging.
Excellent. It's almost as if we scripted that, Benjamin, isn't it? That I said, and you may, if you go to court, be lucky enough to meet a judge, and then Benjamin comes in and backs me up on that statement. So thank you very much, and well done for attending. It's a great opportunity. If you are in Brisbane at any stage, feel free, and I encourage you to go to the Supreme Court Library. The Supreme Court Library is one of the best libraries ever. My personal favourite location in the Supreme Court Library is private reading room number 5. If you want a good reading room that has a good location and a great view, try number 5. That's a good one. And the librarians there are excellent. They will support you in terms of your legal studies. And the material that's available through the Supreme Court Library is not just the paper versions. It is also those materials online which are available to you. So it's part of a great deal of material available. Benjamin. Did you want to add something there, Benjamin? Okay. And sometimes I'm looking for people if they unmute their microphone, and feel free to add to the contribution. So go to the Supreme Court Library, go and check out the courts wherever you might be, and try and speak to some practitioners. And hopefully, like Benjamin, you may get to speak to some judges also. Remember, of course, that your legal professional career begins now. We call it your professional identity. Have a look at the commentary in the text, pages 37 to 40, in that regard. It will stay with you. Now, for your first assessment, you'll be aware that part of your task is to provide a case note, effectively, in relation to a case involving professional integrity and the difficulty that a practitioner faced in trying to be admitted because of things that happened at university. So we mention that to you for a few reasons. It's not meant to scare you unduly, but make you acutely aware of the dangers associated with plagiarism, cheating or collusion, which may lead to failure to successfully apply for admission. In the case that we provide you, it has a good end in that the practitioner concerned was not only admitted, but I understand is doing very well. So it's not all doom and gloom, but you need to be aware of these things. When it comes to, I'm just going to ask, this is the first of tonight's informal poll. All you have to do is answer 1 or 2, and this is an ethics type question. As a lawyer, is your greater duty to 1, the court, or 2, your client? So number 1, court, or 2, just give an answer on the chat facility. Just go down 1 or 2 and we'll see what the votes are. We've got votes coming in 1, 1, 1, 2, 1, 1, 2, 1, 2, 1. A lot of 2s, there's about 5 in a row. It's very even split. Okay. The answer is number 1. Your duty, your greater duty is to the courts. But as a lawyer, you have a great number of duties that you need to balance. The first is you've got this overriding or paramount duty, as we call it, to the courts and the administration of justice. You must keep that firmly in mind. You have a duty to your employer, you have a duty to your client, and you have a duty to yourself and your family. Unfortunately, you and your family in law tend to come last. I hate to say it. It's not meant to be a criticism, it's just the reality. So number 1 is the courts, administration of justice, then your client, employer, etc. But you need to ensure that you remain strong in your resolve, because if you weaken in your resolve and you don't stand firm when you need to stand firm, you may live to regret it. So if, for example, some ethics now, you're not fully aware of your responsibilities under the Australian Solicitors Conduct Rules or the Barristers Rules in practice, and you don't apply those rules, then you may find it's a very distressing, difficult time for yourself which therefore means for your employer, your family, etc. So what I'm suggesting is that you must now, this week, source the Australian Solicitors Conduct Rules and the Barristers Rules. We've got them on Moodle, and I don't need to have you read them in detail, but you must be aware of them and you must get a feel for it. And you'll see in there, one of the rules specifically says that your paramount duty is to the courts, the administration of justice. All good? Happy to do that homework? All right. So, any questions? Yes, Matthew.
Without getting too personal and without delving into your personal life too much,
that's all right.
How has your marriage and life held up as you being a practicing barrister still?
Yes.
Many years?
No, that's a really good question, and that follows on directly from the comments that I made last week in terms of stress. Happily married for 40 years, so that's a good start. Really enjoy practicing in law. From a personal perspective, I have been through, 5 or 6 different iterations as a lawyer. My career has not been linear, although in a way it has. And on paper it looks linear, in that I was admitted as a lawyer. I left school in 76, started to study law in 77, really liked it, started to work as an article clerk. We talked about that last week, I think in 82, 83, practiced as a solicitor and admitted as a solicitor in 84, and then I switched to be a barrister in 2016. So pretty much every day I've been doing law, and every day it's brand new and it's different. And what is really has been interesting for me is going through these blocks of time where, say, for 5 or 7 or 8 years, I might be concentrating on one area and then I might switch and do something else. So I've been very fortunate for the last 6 years or 7 years to be involved with the university, which has been great. Tribunal member, work for community legal centres as a volunteer, work in private practice, work in crime or commercial law, criminal law or whatever. So there's a lot of variety there. That's a very long answer to your simple question, Matthew, but I hope that helps. So I think what you need to consider is your well-being. AJ is saying well-being is establishing boundaries. You think of it as a marathon, not a sprint. That's all really good advice. And when I talked about being strong before, that follows on from what AJ said about boundaries. So you're not going to succeed if you let people run over the top of you. You need to be firm, but at the same time polite and professional. You need to look after your mental health. You need to look after your physical health. So for me, for example, I really enjoy golf and bike riding and swimming. They're the sort of outlets from a physical perspective. All right. And what made me change from a solicitor to a barrister? Partly, I think most barristers have a little bit of show off in them and, a desire to be, in a way, front and centre. And so I enjoy being in court. I like litigation is my favourite area. And also it was just a change. I've always thought, wonder what it's like to be a barrister instead. So I'm not going to say that one is better than the other. I've really enjoyed being an academic. I could really see myself being full-time academic. That won't happen with me. But, there are so many different avenues that you can approach your legal studies and develop your career. And AJ, you've had a lot of experience, a broad range of experience as well. Did you want to make any contribution?
Yeah, I think I guess the thing that I would say, particularly if you do decide to go into practice, particularly if you decide to go into a city firm, kind of grind them in, grind them out kind of thing. You need to, this is why I said about establishing boundaries, you need to be able to say, this is my bottom line, this is what I need to do for me. And to some extent, I know it's a terrible analogy, but I guess the fluffy way of saying it is that you can't fill from an empty cup. You can't pour from one cup to another if there's nothing in this cup to start with. You've got to make sure that you've got your own basic needs taken care of on a weekly basis. And there was a point where I had to schedule in me time. And if that's what you've got to do, that's what you've got to do. But you need to make sure that it's there, because the unfortunate reality is that our profession, apart from, I think it's dentists and vets, actually have some of the highest burnout rates that, you know, is amongst any profession. So you really need to get going with that wellbeing stuff first. You know, and then by the time that you hit the end of your law degree, you will hopefully to some extent have had that issue bubbling along for some years. And I know a lot of you are working, so it's all about time management anyway. But yeah, I won't keep prattling on, but yeah, I think boundaries are really good. I had to learn that the hard way. You know, with working in a big firm, it's really easy to just say, oh, okay, yes, I'll do this, and yes, I'll do that, and yes, I'll do this, and yes, I'll do that. You have to kind of figure out that happy medium where you're happy enough to go, yes, I can certainly do that. Would it be possible to shift this around to that, move this? It all becomes about managing people's expectations. And I think if you learn to be a good manager of expectations, and that includes your own and your family's, you know, you're in for a long and happy life like John.
Yeah, so thank you, AJ. Really good comments, and some very good comments in the chat facility as well. People have said the importance of saying no and being prepared to say no. It's really important to do that. Don't be afraid to do it. Doesn't mean you're failing. It just means that you are accepting a reality that exists, and you must prioritize your health and your work. You're no good to anyone if you're not going to be mentally and physically ready for the task ahead of you. So that means scheduling in some breaks. And I like the analogy of the statement of this is a marathon. So just settle into it and enjoy it. And that's where part of my philosophy with the studies is enjoy it first, enjoy the process of learning, immerse yourself in it, and don't worry too much about the marks. The marks will come, but follow some simple techniques that we provide you. Later this evening, shortly, I'll provide you with some commentary about a sample document that I prepared that gives you some further insight into the way that I think you should approach your work. All right, some really good contributions there. And thank you, AJ, for that. Now, in terms of the making of laws, you'll see that Chapter 2 of your text deals with fundamental legal concepts. I'll leave you to read that for yourself primarily, but you'll see that our laws are, I guess, traditional Indigenous laws on the one hand, the laws that we inherited essentially from the United Kingdom. So it will be no surprise that in your legal studies, whilst primarily we talk about the laws as they appear in Australia today, there will be some consistent, if you like, for want of a better term, throwback to English law, English common law principles, some English decisions. You will see some American decisions, but not many. You'll see some from other areas of the Commonwealth, Canada and New Zealand, but not that many. So mostly your law will relate to Australian legislation, Australian case law, but if not, you'll see that there's some reference to the UK. And it wasn't all that long ago that Australia, through its constitution, became autonomous, but not entirely autonomous. And it wasn't until the Privy Council Appeals from the High Court Act 1975 that we actually formally discontinued the process of appealing to the English courts as the highest appeal court in Australia. And it may surprise you that it was as recent as that the High Court as we know it in Australia now became the most superior court that we have in this country. So the Australia Act was only 1986. You need to look at the history and be aware of that history. It's in the text. I won't go further. Now I'm going to ask a poll, quick poll. So on your buzzers, number 1 or number 2. If you had to find Queensland legislation, and I trust that you all have done that because I asked you to do this last week and go exploring, would you prefer to go to number 1, the Queensland legislation site, or number 2, Ausley? 1, Queensland legislation, or 2, Ausley. The votes are coming in and most people would go to Ausley, just slightly. There's no right or wrong answer to this, just interested for your thoughts. I must confess, I tend to go to Ausley more often than I do Queensland legislation. Now, calling a friend. Did anyone find the Note-Up facility in Ausley? Did anyone find Note-Up? Yes? There's a few. Does anyone want to tell us about it? What it was like? No? All right, so the Note-Up function is part of the citator function in Ausley. There are different citators in different websites. Now, did anyone go and have a look at Barnett Jade? Really good website. And I'm just going to share the screen now, briefly. I deal with this in the, oh, I can't find it. I've got so many things here on my screen. I'm just going to stop that and not share the screen. So Barnett Jade is an excellent website, and I'd ask you to please look at that now if you haven't. Barnett Jade provides you with an opportunity also to subscribe. It's completely free, and the idea of subscribing is that you have an opportunity to have information provided into your inbox, if you like, on a daily basis. Now, you should see the landing page for Jade or Barnett Jade, and you'll see here that you can subscribe to Professional, or you can search material for free. You can ask for subscriptions, and you can see here under What's New, subscribe to our digest to stay up to date. So there you click on the link, give your details, and each day or each week or whatever it is that you wish, you'll get the up-to-date cases provided to you. I do want everyone to look at this site during the week. Have a look at the video, What is Jade, on the top right-hand corner. It only takes a minute and you will be inspired, absolutely. The citator in Jade is called Case Trace, and you can see that on the left-hand side. And the material is up to date. So here, for example, we have a decision from the 8th of November in the High Court. And if we just take that case at random, you'll see that this has a lot of really good features. Over on the right-hand side, you'll see some commentary in terms of cases cited, statutory material cited, and citation reports, litigation history. And if you pan down the page, it will provide you with information about cases that are cited, or it has been cited by this decision. Now, this is only brand new, so it's not going to appear as in other cases yet, but invariably it will. And you can see there that it gives your background to the decision, and it refers to cases cited by the decision. So it's a very good way to research and to follow through with the material that you need to find. So this week, please check out Jade, and I'm sure that last week you checked out Ausley and the two legislation websites that we talked about. Any questions about research, just briefly as we proceed? All good? All right. You'll see, I think in week 5, a lot more detail in terms of research, and I encourage you to look at that in advance. And you'll probably need to look at some of these things a few times for it to sink in, but the important thing is that you go exploring. Now, can I have your assurance that everyone has been on to the CQU University Law Library site? Has everyone found their way to the online law library for CQU? Yes? That's one. Not yet. Yes, yes, yes. So we're getting a few, but this week I want to ensure that everyone finds their way to the CQU online library. Can you please do that? Have a look around, explore, and we might ask you, what are your favourite sites on the library website or the library platform, so that we know that you're actually looking at these things. Okay, it's really good fun. Yes, AJ?
I would highly highly recommend that they at least go on and look at the Lexis Advanced Pacific database and also Westlaw. Same. These are two databases that will become your bread and butter, folks. I would really strongly recommend that you start puddling about in them now while John's so lovely and there's no pressure, and you know, you really need to just start exploring this. And that way, if you've got questions about it, you can ask John next week.
Really good point. Thank you, AJ. I agree. They're my two. They're the two platforms that I use most often: Lexis Australia Pacific and Westlaw. All right. Now, I mentioned that Australian law is primarily based on English law, and that's just the reality of the situation. But it's important that you understand that Indigenous Australians and the law is a topic that you must be aware of and undertake some study. So in the text, there's some very good commentary in relation to Indigenous law, Australian law, and the law in Australia. Have a look particularly at Mabo, of course, we all know about Mabo. Have a look at the Native Title Act 1993, and also consider WIC peoples against the state of Queensland. When you look at Indigenous law, they're the three specific things that I want you to consider. Now, I won't go beyond that at this stage. We all know about terra nullius, which has now been exposed as a legal fiction. So terra nullius was the Latin term. It was coined by lawyers initially in Australia to signify that at settlement, Australia inherited the existing common law and legislation of the United Kingdom on the basis of this declaration that Australia was terra nullius, that is, unoccupied land. So, of course, that was a nonsense. And in 1992, the High Court of Australia finally overturned that doctrine of terra nullius. So therefore, given that that doctrine has been overturned, you must now consider the English law and Indigenous law as it applies in Australia. Now, on the website, on the chat facility, we've got some comments. Tim says, you can ring up and talk to a librarian. Thank you. Lexis Advanced Pacific and Westlaw is the correct name for those platforms. Thank you, AJ. Go to databases button, click, then choose the database with left or L or W from the alphabetical list. So it's pretty easy once you get into the library, into the platform. Now, the Australian legal system, that's the commentary from chapter 4 of the textbook. And just speaking of the textbook, one thing is this. That's the current version. That is the prescribed text called The New Lawyer, Foundations of Law. Now, if you have trouble accessing that text, there is an alternative which will work almost as well and in some ways slightly better, and that is the original The New Lawyer, the one with the owl on the front. It's almost the same content. It's almost all of it. In fact, The New Lawyer, the original, is a thicker publication because it has 3 or 4 extra chapters. So if you can't find the current version, please feel free to use the older one. Now, in terms of the assignment work that we need you to cover, I think we've dealt with that mostly. I think that's fairly good. I'm just going to digress for a moment and show you a thing called the sample document, as I've called it. And to do that, I'll share the screen. Has anyone had a look at the sample document or the written assessment guide? Anyone seen that? Yes, we've got one yes. Okay. The reason I'm showing you this is it just gives you an idea of what I think is important in the context of trying to create your legal work. So there's no real magic in the layout. This is a simple Word document. You'll find it under the assessment subheading. But what's important is, well, you can have a look at the content and the layout and look at the way in which that I've referenced the material. There's some content that might help you at an early stage. For example, when you're citing legislation or a case law, in your material, lawyers by protocol do not include the link. So you can see there towards the bottom, the link through Ostley to the case of Humsey Hancock re 2007 QSC. In your work, you will reference that case by its designation rather than providing me with a link through the internet source. You'll see there the way in which we typically use footnote referencing to reference our work. If you don't know how to use footnote referencing, it's really simple. You need to master this technique straight away. All you do is go to, this is going to be silly in a minute. So I went to References and you click over here, Insert Footnote. Can you see that in the top ribbon? It's as simple as that. And that will automatically populate the footnote for you, ready for you to type in the relevant material. Make sure that your paper is paginated. It's a little bugbear of mine if they're not paginated. So you can see in this instance, bottom right-hand corner, make sure there's consistency in your work, and there's nothing wrong with using headings. Now, in terms of the way in which you should go about writing, I've included some extracts from late Lord Denning, and have a read of that commentary because it's interesting in the way in which His Honour would draw the reader in. So, for example, the first bit, and I'll just read the first 2 lines there. So this is the way one of his judgments starts. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get the money back. He may protest to the machine, even swear at it, but it remains unmoved. Doesn't that just inspire to keep reading? You think, well, this is a really interesting case. But you can see what His Honour has done there. It's a series of short sentences, but it's still very readable. It still flows nicely, even more so perhaps in terms of the longer quote below it. And when you're undertaking your work, be aware of this point, and I've got it under the heading of critical thinking, and it's a tip. Many questions ask you to interpret or analyse or evaluate or explain or make a statement by inference. You cannot properly answer the question unless you understand what is meant by the relevant critical skill. In other words, if the examiner in a third-year subject in an examination asks you to interpret something, then you don't want to answer the question as if you're providing an explanation, for example. Now, I know that some of these topics are interlinked, but I am asking you now to at least be aware of the difference and understand that when we ask you to prepare a response to a question, you need to look typically at the first word to get an idea of what it is, what type of critical thinking what your examiner wants you to undertake in that task. Now, does that make sense? Sounds like a riddle. All right, so thank you for looking at that. Proofreading is really important. When you lodge your work, make sure that it is logical, it flows. And sometimes by reading the work out aloud, you'll overcome difficulties associated with long, convoluted sentences, because if you try to read the material as if you're a newsreader and it just doesn't flow, then you probably need to rework it. I hope that makes sense. If you don't like to actually read the work yourself aloud, you can use Microsoft Translate or Google Translate, and it will read the material to you. It might be a boring monotone voice, but it is nevertheless reading the material, which means that you can identify through orally any issues that might arise. And it's amazing how sometimes you can look at your own material and not see the obvious error in terms of grammar or spelling or consistency that is there. I hope that makes some sense. So this all flows on from the idea of being practical in the way you go about doing your work. Now, can anyone tell me, and I'm going to ask you, it's another quiz, proofreading is a very valuable skill. Yep, thanks, AJ. It's really important. You just want to make sure that you cover the basics, you present something that is professional. Now, I'm going to ask here, if you're all on your buzzers, I'll announce the winner to this one. It's a bit of a typing test though. Can you please type 4 words that fill in the acronym IRAC, IRAC. What are the words? What do they mean? IRAC. Type it in. I'm looking to see who's first in. No one yet. IRAC. What does that acronym IRAC mean? Gareth, first in. Issues, rules, application, conclusion. Well done. Just beat Amber, just beat Megan, just beat Benjamin and Nicole. So that's it. So you need to know the issue, you need to know the rule or the rules, you need the application, and you need to form a conclusion. And it is not a country in the Middle East. It does sound like it, but it's not. All right, so what is IRAC? It is a manner of legal, it's a way of thinking about things, legal logic, if you like. We mentioned this last week briefly. You will find this follows you throughout your legal studies and into your career. At the start, I encourage you to use it extensively and quite openly. But after a little while, I want you to have it in your mind as a means of logic, but not actually put it on paper as headings. If I'm reading a second or third year assessment and someone has answered strictly with IRAC methodology using those headings, issue, rule, application, conclusion, I've got to be honest, it kind of drives me a little bit crazy. So it's a way of thinking about a problem. It becomes almost second nature, but it's not something that you should slavishly adopt. Now, I hope that makes sense. So I'm teaching you something with the idea that you take from it the essence of the idea, the critical thinking, and apply it for a little while, but then modify it in a form that is more logical, more palatable, perhaps. I hope I'm explaining that reasonably well. AJ, is there anything that we need to explain in terms of the IRAC methodology beyond what I've said?
No, I think you're absolutely right. This is just, it's just simply a framework that you can use as a set of trainer wheels. That's all it is. It's just a way to formulate your thoughts and get you started when you've got a blank sheet of paper looking at you on screen. You know, you kind of think you're scratching around going, where on earth do I start? This is a good way to kickstart your process of writing. That's really all it is, isn't it, John? I mean, it's just a way to help you get used to the particular way that law requires you to tease out an answer to a problem. And once you've got that kind of thinking on board, you don't have to rely so heavily, like John said, on those headings. You know, you can launch forth with some confidence that you know what to look for. And the other thing, I don't know, your particular end of term assessment, John, is a take-home paper, but in other nasty little subjects like mine and quite a few of the other first year subjects, you will need to do an invigilated exam. And so it's really super useful to have your IRAC technique kind of down pat by the time you get to the end of your first term, because that's when you're going to, if you're doing all of your four subjects for the first term in the first year at the same time, you're going to hit a couple of exams. So, you know, you're going to want to have that framework working for you so that you can go into that exam with some confidence.
Absolutely. And what you'll find is, going back to the Priestley 11, that the Priestley 11 subjects, I think, almost exclusively have invigilated examinations. So when we talk about an invigilated examination, that's the examination at an exam centre, paper and pen, 2 hours duration typically. All right. And check out AJ's week 1 video in contracts. Thank you, AJ, for that. That was for a tip from Timothy. Thanks for the free ad, Tim.
If you want that, I go through what I call an IRAC autopsy, and I just kind of tease apart the kind of things that we tend to look for as lecturers. If anybody wants the link to that, or if you want the link to that, John, I can flick that to you. No worries.
That'd be great, because Gareth says, well, what about me? I'm not enrolled in contracts. Can we access that? AJ, if you're willing to provide that to me, I'd love to put it up on the Moodle site for Introduction to Law. So thank you. All right, well, AJ's kind enough to share that with us, and we'll do that. Now, you might be wondering, why am I talking to you about IRAC? Because does anyone know where in the text the commentary about the IRAC method appears? Can anyone give me a chapter number? This will really test to see if anyone is doing their reading ahead. Chapter 9, close. Chapter 8, thinking skills. Now, I don't expect you to have read the entire text yet, but I would expect, if you haven't already done so, this is another piece of homework for the week. I want you to flick through every chapter. You don't have to read it in detail, but I want you to flick through the whole lot and get a feel for it. It's a really interesting book, and it's not difficult reading, but you've got to take a lot of things in all at once when you're practicing at law. So chapter 8, thinking skills, provides you with a good explanation of the IRAC method. It provides you with commentary about what is legal reasoning. It talks about some of the variations to the acronym IRAC, because IRAC's not the only acronym that we use in this concept. It provides you also with some examples and some idea of how to use this legal reasoning and legal logic in practice. So it's important that you understand that you have an obligation to identify the material facts critical to a decision, then think about what are the issues that arise from that, and then start to think about the rules. The rules part is where we consider the legal research that we've touched on in the first few weeks that we'll deal with in length in week 5. Now, I'm just going to jump back to another important factor that will stay with you throughout your legal studies and career, and that is the Australian Guide to Legal Citations. Does anyone know has anyone done some research on the AGCL? No, AGLC. No, it's death. Okay. So the Australian Guide to Legal Citations is something adopted through and you can look at this through the Melbourne University Law Review. Have a look at the last page. I think I mentioned that perhaps last week. And I think there's some good commentary on the Moodle site. So more homework for this week. You must find a quick reference guide to the AGLC so that you know where to look quickly to get an idea of how you might reference your material. So I showed you the sample guide, my sample document that I prepared on Moodle. That gives you an idea of referencing in practice. The textbooks, the cases, all are good ways of learning AGLC through osmosis. But have a look for the Melbourne University Law Review material. I'll share the screen briefly and give you an idea of what I'm talking about. So the AGLC version number 3, so we're dealing with AGLC 3, comes in a number of chapters. It's quite extensive, but from those chapters we have here a quick guide to the commentary with some of the highlights from chapter 1, further down the page, chapter 2, etc. And it will give you an idea of how you might go about including footnote referencing, we know now how to footnote reference using the word facility and going to references in that. And it talks to you about the way in which we go about referencing material in a practical and professional sense. It also provides some commentary in relation to what we call authorised and unauthorised reports. So authorised reports are those that must be cited in preference to other reported versions of, say, a case. Now, this is all part of this is to make you feel that you are part of the legal community and that you're presenting work in the way that lawyers present work. So in week 2, you're already joining the club. Do you understand? Speaking of that, I'm going to ask you for another quick poll. Now, Benjamin had the honour and the privilege of meeting with a judge this week. When you're in court addressing a judge or a magistrate, type for me, if you would, the appropriate form of address to the judge in court when you're making a submission, for example. Your Honour, Your Honour, Your Honour. And do you capitalise, if you're writing that, do you capitalise either or both of those words? Both, yes. All right, my protocol is I don't capitalise the word your, but I do capitalise the word honour. That's what I do. Of course, unless your is the first word in the sentence, then I capitalise it for that reason. But otherwise, I don't. So, excellent. So, Your Honour, you're in court and you say, Your Honour. Now, what if you happen to meet the judge or just say hello to the judge at a social thing? How do you refer to the judge? Let's say a district court judge. It's at a function, or even if you just happen to bump into the judge at the movies. You've met the judge the day before and you see the judge the next day. Sir, you can't go too far wrong with sir. Someone says Justice, Justice Smith. Last name. Look, the usual protocol is simply judge. So if you're part of the profession, and you are part of the profession now, you can say, good morning, judge. Now that's in a social type setting, or good afternoon, judge. There's nothing wrong with Your Honour as well. How would you address, now we said in court you would address a magistrate by the term Your Honour, which is correct. What if you found yourself meeting a magistrate in a social setting? What would you say there? Because you want to be able to say something. How would you address a magistrate in a social setting? Any thoughts? The answer is generally Mr. or Ms. and surname, Ms. Smith. And it may well be that the magistrate will invite you to use a first name, but you would never use the first name unless invited to do so. Same with judges. Much less likely with a judge. What about if you're in front of a tribunal? How do you address the tribunal member who's hearing the matter? Let's assume it's the tribunal member rather than tribunal adjudicator. So it's a member. Mr. Can't go too far wrong with that. So this is in the actual tribunal hearing. Any other votes? Typically member. So it would be make a submission to a member of the tribunal. Okay, so what about an Attorney General? What if you meet the Attorney General in a social event? Now, you wouldn't say sir, not in Queensland, but what would you do? So within the profession, typically we address the Attorney General as attorney. Okay. Again, there's nothing wrong with Attorney General, Madam Attorney, but generally attorney. Okay, so the reason I'm suggesting this is so that you can feel that you are part of the legal profession, and you are now that you're studying. So take pride in it and acknowledge some of the protocols that are there for good reason and some for because they're established. so that you can feel that you belong. And you do belong, and it's important that you have that feeling. All right, well, I'm just about finished for this evening. I do want you to do the homework that I've mentioned. I want you to have a very clear understanding of the separation of powers. We understand that. We talked about that briefly, I think, last week. So you need to know the separation of powers, because that's where I would like to pick up next week. AJ, have we missed out on things that we need to discuss?
Not at all. No, that's excellent. I don't know how much they need to get into IRAC with your unit. Will they be doing problem answering with your unit?
Well, yeah, we will. And usually at this stage, I'd be sort of going through, but I might do that again next week. And I was looking for the example in the textbook that I used to refer people to, but the numbers have changed, so I couldn't quickly find it. But perhaps we might have time for that. But it's a matter of me finding it quickly. Sorry.
The IRAC method, Mackenzie, is used to answer a legal problem. So normally what will happen is that in order to test a student's understanding of a certain principle or area of law, or several areas of law, we will set for you a stack of facts. It'll be just like a few paragraphs. It might be a couple of pages. Usually my end of term exams are like a couple of pages of facts, and then what you need to do as budding lawyers is go through the facts and work out from reading the facts what legal issues are in play that get brought up, you know, with that particular set of facts. And then you need to provide your advice typically to a client about how, given your knowledge of the areas of law that have been raised by those facts will then dictate, you know, the advice to your client and the legal outcome typically. So for something like contracts, I'm usually looking for advice to a client about whether a contract has been formed, whether it's enforceable, or whether there's something wrong with it, whether a client can get the outcome that they want, whether they're asking for a remedy, no remedy, they might be asking for something else. So that's so then you need to, it's like a scaffold, like I said. So the issues bit is just to flag for everybody what you think the main legal issue or issues are in that set of problem facts. The rules, is just basically you rattling off what you think the rules are or the principles that will apply to that set of problem facts. The application is where you pick up 90% of your marks. And that is where we are looking for your analysis of how those rules that you've set in your rules section actually fit into and dictate the outcome for your client when you're matching up the rules against the facts that you've been given. And then the conclusion, is just what the advice is that, generally speaking, you're giving to your client, or the way that you're answering the lecturer's question. Okay, so that's just a real long 30-second overview of IRAC.
No, that's great. Thank you very much, AJ. And I have found the material that I was looking for. So perhaps if I could just go a little bit over time, if you don't mind. And that's great. Thank you, AJ. So let's take this example. It's out of the original New Law. I couldn't find it in the new version, so it is a change. But here's a simple legal problem, and I'm drawing this from page 270 of the original text. Listen carefully, and I'm going to invite you just to write down what you think are the important legal facts, that is, the facts that might be relevant to the legal problem. So here we go. So your idea is to write down words that you think are important facts from a legal perspective. While shopping for groceries in her local supermarket on a Saturday morning, Catherine sees the avocados are on sale for $1 each. She decides to cook a Mexican meal for dinner that night and to make her own guacamole. She selects an avocado from the display, squeezes it gently, and is satisfied as to its ripeness, puts it in her basket. She then proceeds to look for some corn chips. A couple of minutes later, she remembers that she already has 3 avocados at home, and she returns the avocado to the display. As she does so, Ross, the store manager, stops her and tells her that she cannot return the avocado because by law, she is already contractually obliged to purchase it. Is Ross correct? You see, so that's the scenario. Now, there's a lot of stuff in there that really doesn't matter from a legal perspective. Do you think it matters, for example, that she had selected the avocado so she could make guacamole? Is that important? But people want to tell you this. We've got to know for that. What about the fact that she was shopping for groceries? Is any of that important from a legal perspective? At her supermarket? So what is really important there? Maybe for context, yes, context is important, but what facts are really important? So Ross, the store manager, stops her and tells her that she cannot return the avocado because she's already contractually obliged to purchase it. So the fact that she handled it may be a relevant factor, that she squeezed it may be a relevant factor. The avocado has an extra dimple, maybe, if she squeezed it that hard. So these are things that you might explore. Gareth says something that is not said, that she did not leave the store, is relevant. Absolutely. She put it in her basket. Does that mean that she has contracted to buy it? Is that a legal issue, says AJ? So you can see that from those facts, clients will want to tell you all these things, and they may feel that it's relevant. I mean, for example, the fact that the avocados were on sale, does that make a legal difference to this scenario? I don't think so. Doesn't make any difference at all, really, does it? So you've got in that simple legal problem many facts that are irrelevant. Most of it's irrelevant, to be honest. But you've got some that may be relevant that require you to explore and ask yourself, is there a legal issue? So one of them was Gareth said, she didn't leave the store. That's a fact. So does that then give rise to a legal issue? The fact that she didn't leave the store then becomes the subject of a legal issue, and you need to then go and consider the rules, don't you, around that. So in this instance, it's a question about contract. Ross says she's already contractually obliged to purchase it. So in determining whether Ross is correct or not, you need to extract the relevant facts and then be prepared to go look for the law. Okay. So what is relevant in this instance? I think that she had picked up an avocado, put it in the basket, may be relevant. I mean, in law, it's not relevant. That's not significant, but it might be relevant in terms of providing some context. The fact that Ross has stopped her, that would be relevant from a legal perspective. Really, there's not much in this. It's a very simple legal question. And the answer is, from a contractual perspective, that there is no contract at this stage. So Rachel says, what if there was damage to the produce? Yeah, so the fact that she squeezed the produce may be relevant depending on the extent to which she did so. And AJ says, this is Boot's case, it's an invitation to treat. So from a contractual perspective, it's only once you've essentially been through the process of exchanging the item for the money on the way through to leaving the store that there's any form of contract applies. Okay, so that's the sort of scenario that you need to consider and then apply the IRAC method to it in terms of providing a legal answer to the problem. Ross will run out of customers if he keeps up that attitude. From a practical perspective, I think that's right. I'm not sure it's a true story, but it's a story. Okay, that might do us for tonight. AJ, thank you so much for joining us once again. We really appreciate it, and your kind offer to provide us with some further material in relation to the IRAC method. So that's great. Thank you.
No problem.
Any questions before we go? All right. And the answer is no. Amanda says no, not contractually obliged. Correct. Okay. All the best. We'll finish for tonight and we'll see you all next week. Okay. Bye then.
Hi, John. If anyone needs to hang around to talk about Ross's shop, please let me know.